Welcome to the Real News Network. I'm Dharna Noor, joining you from Baltimore. We've talked a lot on the Real News Network about the Trump administration's gutting of the EPA, but a federal court struck down an Obama-era protection agency rule that the Trump administration was actually attempting to preserve. The EPA rule banned the use of hydrofluorocarbons, or HFCs, which are greenhouse gases used for refrigeration and cooling. But on Tuesday, in a 2-to-1 decision, the U.S. Court of Appeals in Washington ruled that the ban on HFCs overstepped the agency's authority under the Clean Air Act. HFCs are, pound per pound, thousands of times more potent than carbon dioxide when released into the Earth's atmosphere. To discuss all this, we're joined from Washington, D.C. by William Snape III. He's the senior counsel with the Center for Biological Diversity, and he's also the editor of Biodiversity and the Law, published by Island Press. Thanks so much for joining us again, Bill.
Thanks for having me.
So, one of the judges in this case, Judge Brett Kavanaugh, wrote in the court's decision that HFCs don't damage the Earth's ozone layer. What does the science say about this? Is this true?
Well, all parties in the case did agree that the issue with HFCs is their enormous global warming capacity, not their ozone depleting capacity. And that was one of the oddities of this case. But I want to take a step back and just talk about the two judges who ruled against this EPA rule. They are two of the most far right-leaning judges, certainly in the D.C. Circuit, arguably in all of the courts of appeal in the United States. And so I think whether this happens or not will be an interesting question. But I think that if this case were to go to a full en banc hearing of the full D.C. Circuit, I feel pretty confident that there would be a different result. I think that the plain language of this decision by the two-judge majority doesn't even make sense in some areas. We can talk about that in a second. But I think this decision becomes quite interesting for reasons that you pointed out in your introduction, which is it may be the Trump administration that has to create some order out of this chaos. The ironies are rich.
So the use of HFCs came in response to the ban of the more commonly known chlorofluorocarbons, or CFCs, in 1992. What do we know about HFC's effect on climate change? As you said, it's widely known to have an effect. What is that effect?
Well, what we saw when we substituted the HFCs is while they helped in terms of solving our ozone problem, and in fact, the ozone layer, our tropospheric ozone layer, is doing pretty well now, certainly better than it was doing several decades ago, that these HFCs, unbeknownst to us at the time, have huge global warming capacities, as you mentioned in the prelude, thousands of times more powerful than carbon dioxide. So what the Obama administration did, within the context of a multilateral negotiation by all 200 countries on the planet, as an important fact to remember in this situation, is that they use their authorities under the Clean Air Act to basically say, well, now, based upon the language of the statute, we've determined that HFCs are also injurious to the environment, which is what the statute says. And so they went through a process of substituting for HFCs, the way HFCs had substituted for CFCs. And it's that Kavanaugh and Judge Brown said, no, you can't do that. And to me, the most interesting part of this decision is the dissent. It's a very powerful dissent by Judge Wilkins, who's a very well-respected judge in the D.C. Circuit. And he took great issue with how Kavanaugh was giving a tortured definition of the word replace, which is a key word in this decision. So I think Kavanaugh was up to bigger mischief than just HFCs in this decision. I think that there is, despite the fact that the Supreme Court again and again, even with the late Justice Scalia agreeing the second time that the EPA has power to regulate climate pollutants, what you really saw Kavanaugh doing here, I believe, was laying the groundwork through this HFC case of trying to revisit the argument about whether EPA has to regulate climate pollutants. That's really what he was saying in this decision was, hey, when Congress doesn't ratify a decision by the agency for a long enough period, that agency can't go off on its own and just do it. And I disagree with that because I think the Clean Air Act clearly gives EPA the authority. But what Kavanaugh's doing is planting the seed that maybe all these decisions can be revisited.
So, but as you said, the Trump administration and industry have not exactly been known as defenders of environmental regulation. In fact, quite the opposite. So why, in your opinion, would climate denier Scott Pruitt, for instance, and Trump's Justice Department defend this particular Obama-era regulation?
Because while Judge Kavanaugh was on his ideological crusade to neuter EPA, he, in the process, ruled in favor of a Mexican company that should have known for years that the HFC trade was coming on, the replacement was coming on. Again, this multilateral negotiation that Mexico was a part of had been going on for over a decade. And so now has handed a victory to this Mexican company where the US company, Honeywell, and a couple other big US companies have been investing over the course of the last decade to get rid of HFCs and to develop alternatives to HFCs. So this decision by Judge Kavanaugh actually very much harms US companies, very much harms the multilateral fabric that was what was called the Kigali Amendment to the Montreal Protocol, and puts President Trump in a very awkward position as it relates to the upcoming renegotiation of NAFTA. I mean, it's hard to believe that this issue is not going to come up. So it's a headache for the Trump administration, precisely because U.S. industries have been preparing for this change and, in fact, implementing this change for far longer than this rule was even in effect.
Yeah, Honeywell said, quote, "We are deeply disappointed in this ruling because it will adversely impact American innovation, manufacturing, and competitiveness in commercializing next-generation technologies." So let's move on a bit to talk about what chemicals were the companies using to replace HFCs, and what's the effect of those chemicals on the ozone layer and on climate change.
Well, a lot of those are still being tested. The Kigali Protocol that I just mentioned, under the Montreal Protocol and under the Vienna Ozone Depletion Treaty, is implemented over the course of the next decade. Quite frankly, not all of those substitutes have been ironed out. There are families of new substitutes that will not have the same pollutant impact, both on the ozone layer or on the climate. And so that's what Honeywell was talking about. Honeywell, DuPont, a lot of U.S. companies have been investing a lot of money and reaching some success in coming up with these substitutes. So that's part of what's going to be going on over the next decade, and hopefully this decision does not slow that down. I don't think that it will, but this decision is not good news for what otherwise had been a pretty orderly transition from one batch of chemicals that we had discovered were bad to a new set that we think would do the trick.
So is the overturn of the ban of HFCs final, or could the EPA or the Justice Department pursue this any further?
Well, as a matter of law, EPA and now the Trump administration, the Trump solicitor, they have at least two more bites at this apple. They can ask for an en banc hearing, which is a full DC Circuit Court of Appeals hearing. They could ask for that, and that would be what I would suggest that they do. And they can also, depending upon the result of that, appeal to the Supreme Court. And I think, quite frankly, this would be an interesting case for the Supreme Court. The Supreme Court has taken an interest in some of these Clean Air Act cases. So the Supreme Court taking a look at this is not outside the realm of possibility. But I think the first step is to have the full DC Circuit take a look at this. Because, again, these two judges are pretty far outside the mainstream, who were the two that just happened to be the panel that was selected here.
All right, William Snape III, Senior Counsel with the Center for Biological Diversity and the editor of Biodiversity and the Law. Thanks so much for joining us again, Bill.
Thank you.
And thank you for joining us on the Real News Network.